This is the time set for oral argument in State of Montana versus Quincy Smith. I assume counsel are ready to go. Mr. Fjeldheim, you can commence.
I think I'll go second.
Oh yeah, it's
Thank you,
Mr.
Ron.
Schulte. You're the appellant. Sorry.
Thank you.
Thank you, Chief Justice. Your honors, may it please the court, my name is Dwight Schulte, and I am appearing on behalf of Quincy Smith. Your honors, Ravalli County Sheriff Deputy Monaco was investigating a speeding ticket. He made contact with Quincy on Hidden Valley Road in Ravalli County, Montana. He turned around to make contact with Mr. Smith and activated his overhead lights. Mr. Smith was only on video with the lights activated for approximately 1 second before he left the screen. Mr. Smith was very near his home. He turned left up his driveway, parked in front of the garage within the curtilage of the home, turned off his lights, and exited the vehicle. Deputy Monaco, after making contact with Smith, encountered Mr. Smith at his home approximately 21 seconds later. He turned up the 350-foot driveway, crossed an exterior fence line into the 5-acre parcel, then crossed an interior fence line that surrounded the home and the garage before making contact with Mr. Smith. Now,
Mr. Schulte,
Smith,
excuse me just a minute. I was looking at the video. I didn't see any signage on either of those roads. Am I correct about that?
that is correct, Your Honor. There are not any signage denoting no trespassing or no entry on the exterior or interior fence line.
And counsel, I'll just ask you a quick question about the facts you've just given us, specifically about the timing of when your client turned the lights off. In your chronology, it was after he stopped at the house. It seems like there's other evidence in the record that he went black quite earlier than that.
Your Honor, Mr. Smith and the passenger, Mr. Hennequin, testified that they did not turn the lights off until they parked at the house. Deputy Monaco testified that at some point as they approached their parking spot, they turned their lights off. The district court's findings in this matter made no finding that they blacked out or turned their lights off. I believe the district court's findings were that they turned their lights off and parked.
It could have been an indicator that they're not on the video for a longer period of time if they in fact had gone black earlier.
And Your Honor, that could be right. However, if we look at the angles, the cruiser cam would not have had line of sight on the vehicle regardless. We watched the vehicle leave the frame of the camera, and it would not enter again until Deputy Monaco made contact with Mr. Smith in his driveway in front of the garage.
Thank you.
Thank you, Your Honor. Your Honors, the baseline for a right to privacy is the curtilage set forth by the United States Supreme Court, the 4-part test in Dunn, that was the property enclosed around the curtilage? What is the use of that property? Has there been anything done to close off that property from view? And the nature, the proximity to the home. Now, we have Appendix C, Your Honors, which was admitted at hearing in this, and it shows the curtilage of the home. It shows the interior fence line. It shows the landscaping that was done to block the home from view, and the interior fence line encloses just the yard and the garage and the home. Now, that's the baseline, Your Honor. As we know, Montana has a great constitution, Article 2, Section 10, that can expand that right to privacy outside of the curtilage. However, I don't know that that's an analysis we need to do today because Quincy was in the curtilage. Additionally, he gave Deputy Monaco express instruction that he was on private property and asked him to leave. He also asked Deputy Monaco to secure a warrant if he would like to come back. Deputy Monaco did not, and Quincy was searched and seized. Now, during the pendency of this case, Your Honors, the United States Supreme Court took up the issue of misdemeanor pursuit in Lang v. California to determine if there was a blanket warrant exception for misdemeanor pursuits, and that court found no. Your Honors, it found that they were reluctant to create a new warrant exception. And they held that when a minor offense alone is involved, an officer should get a warrant. However, a suspect's flight can change this calculus, and an officer is to look at the totality of the circumstances to determine if an emergency exists and exigent circumstances of preventing violence, destruction of evidence, or escape from the home create that emergency circumstance. Now, when we apply Lang to the facts at hand, first, do we even have a flight? And it was Mr. Smith's testimony that no, there was no flight. Deputy Monaco testified that he thought Quincy may have sped up around the corner, and that as he approached his parking spot, he extinguished his lights. Those are the two facts of potential flight. However, the video shows Quincy braking around the corner that Deputy Monaco indicated he was speeding up on. Second, Your Honor, when we look at the totality of these circumstances, there was no danger to anyone. There was no threat of violence. There is no destruction of evidence. Deputy Monaco is admittedly investigating only a speeding ticket. And third, Your Honor, there's no issue with escape from the home. Quincy didn't go inside and simply lock the door. He waited, he talked to Deputy Monaco, he asked him to leave, and there's only one road in and out of this 5-acre parcel. There was no threat of escape. So when we look at the totality of those circumstances, Deputy Monaco did not have any sort of exigent circumstances under the Lang case to create a warrant exception. Another route, Your Honors, is the Montana Constitution, which affords, as we know, greater protections than the United States Constitution. Article 2, Section 10, the right to privacy. Article 2, Section 11, the right to be free from unreasonable search and seizure, creates additional protections where Quincy had a right to privacy and curtilage is part of the home. And then the right to privacy is at its pinnacle, and warrantless searches are per se unreasonable. No warrant exception existed. There were no exigent circumstances. Deputy Monaco testified he had the ability to get a warrant, and if he wanted to, he should have got a warrant at that point in time, Your Honors.
Well, let me ask counsel. Of course, the officer has a situation at night where the car comes by speeding, violating the law. And he immediately flips. I was surprised by the videotape, how quickly he gets around. And after the defendant's car passes the cruiser, he flips immediately and has his lights on. Now, I don't know, your client testified, gosh, he didn't see any lights. I think someone could have seen those lights within 500 miles that night. But in any rate, the officer only has the information at that point that he's got a speeding. He doesn't know who's in the vehicle. He doesn't know that they live there. They have just pulled into this driveway, not stopping in regard to the lights, may or may not have darkened their own lights, pulled down a long driveway. They could have been anybody. If in fact that blackened their lights, they could have been felons leaving the scene of a crime. The officer doesn't know. And so isn't there some entitlement for the officer to pursue the individuals in this situation, determine who they are and why they are not stopping?
Your Honor, if this stop had occurred in a public place or roadside, yes, the officer could have pursued questions of who are you. However, he was immediately met within the curtilage of the home, for all intents and purposes, the home itself, and said, this is private property, this is where I live, please leave. And if we were to compare it to, let's say, a walk and knock, an officer entering private property and knocking on a door to ask those same questions, you have a constitutional right to say, no, thank you, and shut the door. That's the same situation.
Your
here.
client tells him later, after he enters the curtilage, who he is and that they own the property or are staying at the property, but the officer doesn't know that at the time that he is pursuing them, they may not have even lived there as far as he knew. So I think your position is anytime that an officer would be pursuing a misdemeanor, he must stop at the curtilage of private property, even if he doesn't know who they are.
Your Honor, that is a good point. I think that in practicality, when evaluating these facts, that Mr. Smith invoked his constitutional rights when he told Deputy Monaco that he was on private property and to please leave. I don't think that the violation of the rights occurred by entering the driveway or entering the curtilage. I think it occurred when he was informed this is private property, please leave.
Thank you.
So let me just follow up on that then to make clear I understand your position. Lang says that flight alone cannot justify pursuit into a private residence. And what you're suggesting is that because the officers didn't know, or the officer didn't know it was a private residence when he followed them into the driveway, the point at which the stop becomes terminated or should have terminated was when Smith said, I live here, you're on private property, go get a warrant, not when the officer entered the driveway.
Under these facts, Your Honor, I do believe that is accurate because I don't think there was flight. I think that the evidence shows that Quincy braked around the corner, that Deputy Monaco thought he accelerated around. He parked in his driveway in what both officers described as a normal spot with his lights off. Deputy Monaco entered the property and was then told to leave the property.
So counsel, at what point then, after, if he's okay up to the point that he's asked to leave, at what point does this ripen into a DUI investigation?
Deputy Monaco testified that it was approximately 10 minutes before Sergeant Geisinger arrived on scene. Deputy Monaco called in code, which is the highest protocol possible. And during that time, he alleged that he smelled alcohol on Quincy's breath and that Quincy admitted to having 2 beers. At some point during this contact that should have ended, within the first few seconds, that's when Deputy Monaco believes it ripened into a DUI investigation. Your Honors, I think there is one other point to make here in terms of the issue of was there flight or not. Mr. Smith was not charged with eluding an officer, and that isn't the end-all be-all analysis and whether there was flight or not, but it is very indicative. He was charged with just about everything Ravalli County could reasonably justify, with speeding, with DUI, with obstructing an officer, and resisting arrest. They did not charge him with eluding, and one of the elements of eluding is turning off your lights to avoid law enforcement. If they could have, Your Honors, they would have.
You're muted, Chief.
If there are no further,
Oh, Chief Justice, you're muted again.
spacebar down. We'll go to Mr. Fjeldheim.
Thank you, Your Honor. May it please the court, my name is Brad Fjeldheim. I'm an Assistant Attorney General representing the state of Montana. And Mr. Smith did not have a reasonable expectation of privacy in this driveway where the stop occurred. I'm going to point you to the district court order, and the district court correctly applied Bullock to find, and this is page 9 in the order, nothing about the property indicated that anyone merely driving up the driveway to the parking area in front of the garage, which is where anyone driving up their driveway would end up, was unauthorized to do so. And Mr. Smith does not even attempt to argue that findings of fact in here are clearly erroneous, and he can't meet Bullock because nothing unmistakably indicates that entry is not allowed.
What about his point that the officer was asked to get a warrant?
Sure. So I would say two things. Number one is I want to clarify some facts on that. So in the briefing, at least, he said that he was immediately, there was this immediate declaration of private property and an immediate demand to leave, and that didn't happen. What happened was Officer Monaco showed up with his lights on in uniform. He comes out and he immediately says, I caught you at 50 or 57 and a 40. Who was driving? They don't want to answer that question. So he proceeds and continues to ask for license, registration, and insurance. And he asked for license, registration, and insurance or identification alone 11 times before they complied. At one point, Mr. Smith actually, Officer Monaco addressed Mr. Smith and said, are you able to provide license, registration, and insurance? And Mr. Smith pats his pocket and says, of course I am, but doesn't provide that, doesn't provide identification at that time. What I want to do, and I think that this is important because I think that the briefing, there's some stuff that I want to include.
Counsel, my question is what about, do you have an expectation of privacy on your own property if an officer is on your property and you say, come back with a warrant?
No, I don't think you do, not under the tests that would apply in this case. And I think if you look at Bullock, you start there. But since Bullock, this court has applied Bullock, the test in Bullock, along with the Katz test. And the Katz test is what it has two factors. It's a threshold test under Article 2, Section 11. Whether a reasonable person has an expectation, or whether a person has an expectation of privacy that society is willing to recognize as objectively reasonable, and the nature of the state's intrusion. Now, there's two cases that I want to point this court to that aren't brief. State v. Hubble, and I can cite those cases for you because you don't have them. 286 Mont 200, a 1997 case, and State v. Dunn, 2007 MT 296. In those cases, this court applied the Bullock test in circumstances similar to this, where there's law enforcement entering property, and they applied the Bullock test and they applied the Katz test. And so when you apply those tests, it gets to not only the objective reasonableness of the intrusion, but also the nature of the intrusion. And I can just go to Hubble. I'll explain this case really quick, just so you understand it. And the first thing that I want to mention about Hubble is that there's a lot of focus on curtilage in this argument. Hubble, this court said curtilage is meaningless in Montana. It's meaningless, doesn't mean anything. Bullock replaced the analysis of curtilage. It's a broader protection than curtilage is under federal law, and it replaces that curtilage analysis. So it doesn't even matter. We're talking about curtilage. Really, we're in the Bullock area. That's what we should be talking about, in addition to Katz. Now, I'll explain Hubble. Hubble called 911, said, I shot my wife. I need to be arrested. So we met law enforcement at a convenience store. Sure enough, wife is sitting in the car, neck's bleeding, and he says, arrest me, tells him who he is, and tells him where he lives. So officers go to his property, enter the driveway off the highway, pull in, park in a place that the officers deemed to appear as if people would park there if they're going to this property, look around the property up to the front door, see a lot of blood, see bullet holes in the front door. There's a home entry issue in that case, which that doesn't apply here. What this court said is that Mr. Hubble did not have a reasonable expectation of privacy in the property around his home leading up to the front door. And this court relied on Bullock to explain that Hubble did nothing to prevent casual visitors or law enforcement from walking to the front door and observing. There's no fence or gate, no signs indicating entry was prohibited, no trees or bushes to shield the property, and it's an unobstructed walkway to the front door. And then they also considered the nature of the state's intrusion, which I think gets to your question, just to say, in a long-winded answer, so I apologize. But they said officers did nothing other than what a casual visitor would do, parked in an area where a visitor would park. And this court said, had the police entered the property to sell tickets to a policeman's ball, they would have had a legitimate right to do so. And so here, if we work this back and apply these tests to this circumstance, Mr. Smith asserts that he had an expectation of privacy in this driveway, and Officer Monaco could not pursue him there. Officer Monaco entered this property with probable cause for a speeding violation. That matters. He clocked the vehicle driving 57 and a 40 in a residential neighborhood at night, 30 seconds away. He also immediately pursued all of these things that the court's asking questions about matter. He activated his lights while the vehicle was still in line of sight. He pursued him on a public roadway for approximately 30 seconds, and he followed him up the driveway on a path that a visitor would take to access this property, the same path, just like the facts in
Hmm.
Hubble.
Mr.
Mr. Fjeldheim,
Go ahead.
I'm sorry.
Well, one thing about Hubble that I wanted to ask you about is that in applying the Bullock test there, we included, first of all, Hubble was a property search. There wasn't any kind of pursuit. And we said in there that we look to these factors to determine expectation of privacy. And one of the factors we mentioned is the extent to which the person took measures to shield property from public view, which you've mentioned, to communicate that entry is not permitted. So getting right to Mr. Schulte's argument, at the point when Mr. Smith communicated that entry is not permitted, he demonstrated his actual expectation of privacy, and applying these tests, why wasn't that reasonable at that time?
I would say that a demand to leave after an officer is lawfully there is different than prohibiting him in the first place. And I think that this gets back to the nature of the intrusion.
So, counsel, let me ask you then, so if an officer pulls up and he just decides to have a look around and he's asked to leave, he's already there, you think the demand to leave is unreasonable?
In that situation, no, but I think, again, it matters that there's probable cause for this speeding violation that occurred 30 seconds away. So the pursuit matters. It's not necessarily hot pursuit, as discussed in the briefing, because there's no home entry here. But the pursuit does matter.
But does the charge also matter? I mean, and this is where I kind of am stuck in terms of the chronology as to when it may have ripened into a DUI investigation. Because in Lang, I think it was in Justice Alito's concurrence, he talks about, I think, where they draw distinctions in Welsh between misdemeanors being serious crimes, and it's one of his picks with the Lang decision, versus minor offenses as being defined basically as non-jailable. I mean, doesn't it make a difference if the investigation prior to being asked to leave is for a speeding ticket versus a DUI?
Oh, just a sec. I'm going to dovetail on to Justice Shea's deal. So to please tell us how Lang applies in these facts when you answer Justice Shea's question.
Sure. Well, I would start by addressing your question, Justice Shea, and I would say there's also an obstruction issue here, because as soon as Officer Monaco arrives, these men are refusing to comply. They don't. Again, I go right back to, they did not immediately declare private property and demand him to leave. They eventually did, but it was in the context of them refusing to comply with his reasonable request, his reasonable investigation into a speeding violation for which he had probable cause. And so I think at that point, it's ripened into an obstruction investigation as well. And that happened long before the DUI. And it did eventually ripen into DUI. He admitted to having a couple beers, but the obstruction investigation justifies that purpose as well. And again, because he's not exceeding the scope of a reasonable stop in these circumstances, I mean, Officer Monaco, again, he's just trying to get license registration and insurance. This is something he can do under the stop and frisk statute. I think that's 46-5-401. I mean, specifically authorized when there's particularized suspicion. So a lower standard than probable cause, which he has here, authorizes his presence on that property and his ability to do a reasonable investigation. Now, to address Lang, I don't see how Lang applies. I honestly, I think it somewhat informs this. It's an interesting case to read, but it's honestly the holding in that case. And I'll give you a little background on that case. So the Court of Appeals in that case in California applied this categorical rule that allowed hot pursuit of fleeing misdemeanors. The Supreme Court of California said, no, that's a well-established law. We're not even going to consider this. Appellant appeals, and the state of California says, we don't like this categorical rule. We're not even going to advocate for that position with the Supreme Court. So the U.S. Supreme Court has to appoint amicus to advocate for that position. And so the issue in that case is whether or not a categorical rule can be applied to hot pursuit to pursue a fleeing misdemeanor into a home. And so Lang, in my view, Lang doesn't apply, just like hot pursuit doesn't apply. Exigent circumstances don't need to be present here, because you go right back to the test in Bullock. There's no reasonable expectation of privacy. The district court found that repeatedly, and I'll point to another thing that the district court said in the same paragraph. Without more, landscaping and field fencing do not confer an expectation of privacy equivalent to that conferred upon a residence. It just doesn't do it. Bullock has replaced the curtilage analysis under federal law. It is our law in Montana. It is a broad right, offers broad protections. And if there's not a reasonable expectation of privacy there, it's not like entering a home. It's not. I can also go to curtilage, and I want to address this too, because there's a case, U.S. Supreme Court case, Florida versus Jardines. And so we talk about curtilage and the appellant talks about
Excuse me, Mr.
Oh, go ahead.
Fjeldheim.
Yes.
You keep saying that Bullock has replaced the curtilage analysis. Bullock is a Montana case. The curtilage precedent in lineage is a Fourth Amendment basis. And I don't see where you've analyzed in your brief anywhere how to synthesize and reconcile the cat's reasonable expectation of privacy analysis with the Fourth Amendment curtilage analysis, much less how you say that our assertion in Bullock or analysis in Bullock has replaced it and rendered it meaningless under Montana law, which of course is subject to the Fourth Amendment. I'm not tracking any of that logic. Could you straighten me out on that, please?
Sure. So, and you know, that we're at an inherent disadvantage here. Hubble's not briefed. I get that. But I encourage you to read.
I've
Hubble.
read Hubble, and I won't even pick at you about the fact that the state, who's often in this court telling us we can't listen to any or consider anything that's not on the briefs. And now we're having an oral argument on Hubble. Let's set that aside for the moment. Please explain this all to me.
Well, I would say this. In Hubble, this court said that curtilage was meaningless. That's quote. This court said that there was an argument in Hubble that, well, curtilage still applies because it offers more protection than Bullock would. And this court very specifically said, no, it does not. The protections under Bullock are broader than the Fourth Amendment. There are still protections under the Fourth Amendment. They still apply, but they are protected with the Bullock test. And you can go to the United States v. Dunn factors. You can and make this a curtilage analysis. But again, those factors are very similar to Bullock, and he doesn't meet them here. So if Bullock is protecting that Fourth Amendment right, it still applies, but Bullock accounts for that. It's a broader
Okay,
right
so as far as
Montana.
excuse me, Mr. Fjeldheim. So as far as the curtilage argument goes, then, is it your position that the Bullock would support that if curtilage is meaningless, that you could have a 10-foot high fence around your property, but if you don't have a gate across the driveway and the officer, or there's a tip or something that there's marijuana growing on the side of the house that might be visible from the end of the driveway, and you drive up a 300-foot driveway to just look around, you can argue the plain view exception because the property owner had no reasonable expectation of privacy in that circumstance? Well,
I think that I could certainly make an argument. At the end of the day, what Bullock is a totality of the circumstances test. And you look at all the things that matter. So a 10-foot privacy fence would absolutely change the analysis, or at least figure into the analysis. And here, again, reverting right back to the district court order, there's field fencing here. It's different. There's no end. It's got to unmistakably indicate, and perhaps a 10-foot high privacy fence might make that indication unmistakably. It's very possible, but under Bullock, you consider all of the factors, and then you look and see whether or not there's an unmistakable prohibition from access. And when there's nothing present other than a long driveway, some landscaping, and some field fencing, under Bullock, they don't get there. And just to distinguish Bullock, remember, we're in a secluded area in the mountains. They're 7 miles up a Forest Service road, and it's distinguishable in the briefing, so I won't belabor it. But that's not the case here. There's no trespassing signs. There's no contours in the land. This is a residential neighborhood, and the driveway abuts a public road, whereas speeding violation occurred 30 seconds away, and there's no contention that didn't happen. In fact, he admits it repeated and apologizes for it. And so really what this comes down to, and this is why it makes sense to look at Hubble and to look at Dunn, which I can explain here, is that you consider all of these factors and what goes into it. And the nature of the intrusion here is important. And in Dunn, what happened in Dunn was there's a house, residential neighborhood in Missoula on a 1-acre lot. there's vegetation that completely obscures the house from view from the street. It's a noise complaint. Officers respond to the residents. There's a crescent driveway with 2 openings through the vegetation. And the officers pull in and they park where any other visitor would park. There's no one in the house. The house is black, but they hear noise and see smoke in the backyard. So they proceed around the side of the house on a path that visitors would take and make contact with the people in the back. It's a fenced backyard. And Mr. Dunn comes over and eventually they arrest him for an outstanding warrant. And he on appeal raises this expectation of privacy issue. And this court very specifically said he didn't have one. And they said it's not objectively reasonable to expect a privacy interest when law enforcement is investigating an ongoing crime that is occurring in their presence. That doesn't pass the smell test. That's what this court is saying. They took a step further in that opinion and said the ongoing disorderly conduct invited the police to investigate. And that goes to objective reasonableness, but the nature of the intrusion, and I think that what matters here and is important here is that they acted in a manner consistent with investigating the noise complaint. They didn't expand the scope of this stop. Nothing that Officer Monaco did expanded the scope of this stop, other than being there with probable cause in the first place. And Bullock doesn't prohibit entry unmistakably. So he's there lawfully. And then when he starts to investigate, he just continually demands license, registration, and insurance. It's frustrating the purpose of the state's compelling interest to enforce the law. I mean, it doesn't make any sense. Oh, go ahead. Excuse me.
Oh, finally, I figured out what the problem was on my computer. I've been trying to ask questions here. Mr. Feldman, can you, and I'm looking at Lang, page 20, 21, 22, and it specifically says we reject the categorical rule, which is a combination of a misdemeanor and flight. And that's even assuming that we have flight here, which I don't know that we do, but that they adopt a case-by-case approach and quote, when the totality of circumstances shows an emergency, such as imminent harm to others, a threat to the officers himself, destruction of evidence, or escape from the home, the police may act without waiting. So those are the exigent circumstances that the Supreme Court has outlined that we have to follow. We're certainly able to provide more protection than that, but the court very eloquently discusses the importance of the home in the context of the Fourth Amendment, and that it's elevated above all else. So, you know, and then they lay out the exigent circumstances that allows police to not wait. And I don't see how we have any of that here. We have a speeding ticket. And indeed, Lang was a noise complaint that they followed through on. I don't see a distinction. And how do we get beyond the clear parameters of Lang in this case?
Well, I agree with you that the home is sacrosanct under the law. It is, but there's no home entry here. And to determine if he has a reasonable expectation of privacy in this property, similar to a home, you go to Bullock.
But we're not talking about, we're talking about a rural area of the county, 5 acres. Most people don't have 5 acres. We're not talking about Lawrence Street or a place in town where there's alleys and that sort of thing. This and isn't that part of the totality of circumstances that we need to consider? The fencing?
Yes, it is. Absolutely. The landscaping and field fencing, as the district court explained. I mean, I encourage you to look at this map because this is a residential area and it's basically in Florence. It is technically in the county, but it is right next to Florence.
350 feet is almost, because I've had to plow that before, is almost the length of a football field.
It is. It's a long driveway. There's no doubt, but that doesn't meet the facts in Bullock or the test in Bullock. Simply having a long driveway does not convey a reasonable expectation of privacy that is objectively reasonable. And if there's not a protected interest, then we don't get to Lang.
Well, we certainly built our 350-foot driveway so that we would get off the road and have some privacy in our home.
But the intention has to unmistakably indicate that entry is not allowed. So is it his intention to have a 350-foot driveway so the UPS man doesn't come? I mean, I think that if you look at, I go back to this curtilage idea with Florida versus Jardines, I mean, the court in that case talks about, number one, just being curtilage under federal law doesn't mean that it's prohibited entry. There's an implied license, the court calls it that, for law enforcement, and including solicitors, hawkers, and peddlers of all kinds, including the nation's Girl Scouts and trick-or-treaters. So that evidence must indicate to these people who might call upon these folks at this residence that they can't come in. So UPS man, do you want to exclude the UPS man?
Well, they did exclude, they told the police to leave, that it was their private property and to leave.
I get that, and so I said this before, and I think this is a point worth reiterating. Excluding in the first place is different than trying to frustrate the purpose of a law enforcement officer who came in there with no indication that he shouldn't. And so once he's there lawfully under Bullock, then he has the authority under state law to conduct a reasonable investigation. And again, that's why the nature of the intrusion matters so much.
Mr. Fjeldheim, I have to get after you about this again. The UPS man and the nation's trick-or-treaters are not who the Fourth Amendment is defined, is in place to protect us from, first of all, to make that inane point. But secondly, I just pulled up Hubble since it wasn't briefed, and you're mischaracterizing what we said in Hubble about the difference between this CATS test and the US Supreme Court test. We recognized in Hubble that the Montana Constitution, as indicated by Justice McKinnon's question, can provide greater protection than the Fourth Amendment. We analyzed the fact pattern in Hubble under CATS, under Article 2 of our Constitution, to find that there was not a reasonable expectation of privacy. And then we recognized, and that's where the meaningless language concept came about. And then we recognized that we also have to look at this under the Fourth Amendment. And we looked at the curtilage test, and we found that it wasn't violated or implicated on the facts of the case. But it's not accurate for you to continue to tell us that the US Supreme Court curtilage analysis is meaningless across the board. And we recognized expressly in Hubble that curtilage under the Fourth Amendment is a Fourth Amendment protected place, which then, if you're in the curtilage, implicates some exception to the warrant requirement that has to apply. So I can't understand how you just want to gloss over all of that.
Well, let's not. Let's address Dunn, United States v. Dunn, the curtilage factors. And I have them here. United States v. Dunn, 4-factor test. The proximity to the home of the area claimed to be curtilage, whether the area is included within an enclosure surrounding the home, the nature of the uses to which the area is put, and the steps taken by the resident to protect the area from observation by people passing by. So when you apply those factors, you get to the same result as you do under Bullock. There's no larger protection under the Fourth Amendment here when you apply the Dunn factors. And I would reiterate that under federal law, which is what we're talking about here now, even if it is curtilage, it doesn't automatically mean King's X, as Mr. Smith is claiming here. It doesn't mean that. There is an implied license under federal law, Florida versus Jardines. If you follow a path that is unobstructed, that a visitor would follow if they were going to access this property without indication that they shouldn't go there, then you have an implied license to enter.
So counsel, and I hate to keep harping on this, but again, I think chronology is important here. Would you agree that if there had been if the request to leave the property was immediate, that the officer should have left the property, when at that point, all we're talking about is a non-jailable speeding offense?
Well, no, I don't know that I would agree with that.
I mean, if a no trespassing sign would be sufficient to keep him off the property, why isn't, once he comes onto the property and is asked by the property owner to leave, what's the distinction there?
Well, I think the distinction is that it's different to exclude someone in the first place under Bullock, and then demanding an officer to leave when they're there for a lawful purpose. And I think
Even if the
that's
lawful
distinction
purpose
here.
is a non-jailable offense.
A speeding ticket that he has probable cause for. Yes, I would go that far, because all he needs to do at that point is ask for license, registration, and insurance. So yeah, I guess that's not the answer you were looking for, but I would say that there's still, if you go to this court's cases and apply this, the nature of the intrusion is reasonable here under the circumstances. And again, we don't want to render a speeding violation meaningless within 30 seconds of the home. That doesn't make any sense.
Well, it doesn't render it meaningless. All it's saying is that if you're asked to leave and it's a non-jailable offense and you're on private property, you're asked to leave, you can get a warrant. I mean, if it's serious enough for a warrant exception, it's serious enough for a warrant.
Yes, and I understand what you're saying. I go right back to what Justice Rice was getting to in his questions to the appellant. There's all sorts of information that is missing here. He knows that there was speeding. No doubt that there was speeding. He clocked it on the radar. But he doesn't know who's driving. He doesn't know who they are. He doesn't know that this is their property. There's all sorts of things. Whether or not there was Bullock indication here. You know, there are reasons that the law enforcement, there's a policy reason that law enforcement should pursue this and meet their compelling interest to enforce the law.
Well, but counsel, but always the actions of law enforcement are governed by their suspicion of what's going, they have to have something particularized. The only thing particularized here is a speeding violation. So I don't accept that they are able to follow somebody that's speeding because potentially there may be some felon in the car. I mean, I think they have to articulate, and the only thing here that we have is a speeding violation. That's
Yes.
that governs the scope of the detention.
Yes, and I understand that. And I think that that's why when you have to make this determination under this court's precedent and this court's laws as to whether or not there was a reasonable expectation of privacy in the driveway at all. And so that's why you have to look at Bullock. And if this court wants to read Hubble, and I appreciate your reading of that, Your Honor, Justice Sandefur, if you want to read Hubble in the way that says, well, we're still going to go to the United States v. Dunn factors every time, then you got to go there and you got to take that analysis. But my point is that there's no reasonable expectation in the driveway because he doesn't meet the Bullock test and he doesn't meet the Dunn factors, United States v. Dunn. And so if there's no reasonable expectation of privacy, then it doesn't matter. That's why
Mr. Fjeldheim, no, even under the CATS test, can you at least appreciate the difficulty in what it appears you're trying to sell us, that in Montana, in a rural area, 350 feet off of a highway, you have no reasonable expectation of privacy as a general proposition outside your garage door and your driveway. That's what you're trying to get us to buy here. And that's really hard to take as a general proposition. And I just, am I mischaracterizing your argument? Because if I don't want to do that, if I'm misunderstanding you.
No, I mean, my argument is certainly that there's no reasonable expectation of privacy here because he fails to meet the terms of the Bullock test and he fails to meet the CATS test.
And then okay, excuse me, I'm sorry. Go ahead and finish. I don't want to.
I finished.
And then secondly, in your brief, and I realize these are, we argue all aspects of these issues, so I'm not chastising you about that. But in your brief anyway, then you seem to fall back to an exigent circumstances assertion, which we're not challenging, nobody's challenged about yet at the moment, but you would at least concede that if we're having a discussion about exigent circumstances, there has to be a reasonable expectation of privacy as a threshold matter. Would you not?
May I answer that, Your Honor?
Yes, please.
Yeah, well, this is a hard case for me. I wouldn't go there. I didn't write the brief, and so I wouldn't have went there. And I don't think this court should go there because it's not necessary to go to exigent circumstances when there's no home entry and there's no reasonable expectation of privacy under this court's law, which is Bullock and CATS.
Okay, thank you.
Thank you.
Thank you, Mr. Feldheim. Your time has expired. Mr. Schulte, this is your opportunity to respond.
Thank you, Chief Justice. Your Honors, I believe Justice Sandefur has kind of hit the nail on the head here, that it's pretty hard to look at this situation and determine that Mr. Smith did not have a right to privacy on 5 acres in the countryside of Ravalli County, Montana. That we're talking about 2 fence lines, first an exterior fence line, and second an interior fence line that clearly denotes the baseline set by the United States Supreme Court of the curtilage of the home. And the curtilage is considered the home for Fourth Amendment purposes. We also have the testimony of the homeowners, Jacques and Carly Hennequin, that they bought this property because of its privacy, and that they moved back to Montana, in fact, to live in the countryside, and that there's foliage and landscaping to obstruct the view, and that the house really isn't even in view of the road because of these intentional things that were done. So under the
Well, Mr. Schulte, let me back up. I mean, what about Mr. Feldheim's point that if in the absence of no trespassing signs or a gate, that if an officer could have come up in the middle of the afternoon and seen it to sell tickets to a raffle and for the policeman's ball, and he comes up there and he sees the property owner committing a crime in the yard, is there a reasonable expectation of privacy there? I mean, I think that it appeared to me that you were arguing before Mr. Fjeldheim that you were acknowledging that there was a right to enter, but that they should have left once that the expectation of privacy effectively matured once the officer was requested to leave. Is that, I'm just trying to nail that down there where we're at on this.
Certainly, Your Honor. I think that's a 2-part question. So first, Your Honor, under the Bullock test, unmistakably indicating that entry is not permitted. If we take away all of the signage, the visibility, we have the property owner saying, please leave, this is private property. So we have an unmistakable indication that entry is not permitted. Regarding somebody—
Before you move on from that, Mr. Fjeldheim says that unmistakable communication to leave the property did not occur until after there was particularized suspicion for an obstruction investigation. And it's one thing to prohibit entry, but another thing to interfere with an ongoing police legitimate function. So maybe you could address that as well.
Certainly, Justice. I would point the court to the transcript of the hearing held at page 56. Deputy Monaco was asked, and it was very clear that they wanted you to leave. Answer, oh yes. From the very beginning, answer, sure. He was on notice immediately that he was being asked to leave private property. And getting back to Justice Shea, I think that with a 350-foot driveway passing through 2 fence lines, that any person driving up that driveway is going to know they're on private property and going to know that they're only welcome if the property owner wants them to be. So we have unique facts here in that Deputy Monaco was trying to investigate a speeding ticket. And that's why I think that under these facts, when he made contact with the driver, and the driver is, for all intents and purposes, in their home, because curtilage is part of the home, says, no, thank you, your officer, come back with a warrant, that's a clear invocation of where those Fourth Amendment rights begin. However, if an officer were to show up in the afternoon and enter this driveway, they absolutely know they're entering a major piece of private property, and they know they're entering the curtilage of the home. So I think those privacy rights do extend to somebody driving up the driveway.
Counsel, what you've just said is that Officer Monaco is there to investigate a speeding violation. So if he's there to investigate a speeding violation, is he entitled to ask for the driver's license registration of the vehicle?
If the stop is lawful, Your Honor, and the stop is not lawful when it runs afoul of the Fourth Amendment. Quincy's right to privacy and his right to be free from unreasonable search and seizure that he expressly invoked.
Well, this gets back to my question I asked you earlier. It seems like, again, you are arguing that he had no right to be there. He absolutely had no right to enter private property, even though he was investigating a speeding violation. Is that your position?
That is correct, Your Honor. You need a warrant or a warrant exception to invade somebody's home, and without a warrant, an invasion is per se unreasonable.
I think your position is evolving during the course of the argument. Because I understood you to say earlier that, yes, he did have the right to be there to investigate the speeding violation, but at the point he was asked to leave, it was that point that the exercise of the privacy right was made.
Your Honor, I think under this specific fact set that is the bright line. You know, he entered this property and he was immediately told it was private property and asked to leave. And that is a very clear, bright line under both Dunn and Bullock of somebody invoking their right to privacy and their right to be free from unreasonable search and seizure.
So I would follow up then, well, what about the pursuit? Again, we're only talking about a non-jailable offense. Does he have a right to pursue beyond the fence line?
If we look at Lang, Your Honor, he does not. If we look at the totality of the circumstances here, first, was there a pursuit? Deputy Monaco, when he described it, said pursue for lack of a better term. You know, so what we have is Deputy Monaco thinking that Mr. Smith may have accelerated around the corner. We have the video showing him braking, and we have Deputy Monaco saying that he may have turned his lights out a little bit before he parked, but no findings were made by the district court. So first, was there even a pursuit? That is a question that I think the answer is no. But if there was a pursuit, the second question is, do we have a misdemeanor? Quincy was charged with the misdemeanor version of speeding. However, the 61-303 charge is not even a misdemeanor. And then the third, what sort of exigent circumstances do we have that creates an emergency? And there are none here. There was no emergency. There was no threat of violence to anyone. There were no issues with destruction of evidence, and there were no issues with escape from the home. So no, Your Honor, it does not meet the Lang test.
Mr. Schulte, I want to come back to Justice Rice's question, because as skeptical as I am about a lot of the state's argument here, I think that's the tricky part of your Fourth Amendment argument here is you seem to be hanging your hat on the fact that, well, maybe tacitly conceding that the officer could have turned off the road and went down the road, but at the point that he's advised that this is private property, then he's essentially out of bounds there without a warrant and needs to leave. And that seems, could you explain that further? Because I'm having a hard time with that too. Understanding the distinction that you're making there, because I don't think there's any evidentiary basis here to conclude that the officer could have apprehended this at the second he turns off the property as this being anything other than private property. So how do we analytically get to where you want us to go here from a threshold at the point he makes the turn off the highway?
Your Honor, that's a great question. I think as I think about it, in Ravalli County, driving up a driveway at night, I wouldn't do it on somebody's private property because we know that's private property and we know you're not welcome. But we have an officer that's trying to investigate a speeding ticket. And there are two ways to look at this, that privacy right started at the property line when he entered the road, or it started when he was asked to leave immediately upon exiting his vehicle. And I think there's two different analyses that could happen there. I think both of them lead to the same conclusion, that Quincy had a right to privacy and that a warrant or a warrant exception applied. I think in terms of making this argument today, it seemed that the stronger of those arguments was to use Quincy's clear invocation in the curtilage of his home, which is essentially in his home under the law of this country.
Seems to me there's a third way of looking at it, and that is this is clearly a pursuit. What else could it be? As the officer said, and did he have a right to pursue for a non-jailable offense on the private property?
And Your Honor, at the transcript at page 43 is where Deputy Monaco states pursued for lack of a better term, and that's where do we characterize this as a pursuit or not? I don't believe it is, but even if we do, under the Lang test, the exigent circumstances are not met, even if this is a misdemeanor.
So, counsel, could I follow up with some questions, I think from the Justice Sandefur as well as Justice Baker and Justice Rice have alluded to, but is there, in my mind, Lang dealt with misdemeanors. There seems to be an implication that when the police arrived inside the curtilage, and then that Smith does not have a right to say, go away, because now they're investigating this offense and it becomes an obstruction charge. And my reading of Lang is that, a misdemeanor doesn't qualify for invading that Fourth Amendment space absent one of these exigent circumstances. So it really isn't a distinction between the officer. I mean, I guess my question is, could somebody say to the officer who isn't investigating a misdemeanor complaint, any misdemeanor complaint, to leave the property, their private property?
Your Honor, invoking your constitutional rights, I do not believe creates an obstruction investigation. Mr. Smith was clear from the start, this is private property, please leave. But yes, Your Honor, there is not a blanket misdemeanor warrant exception. In fact, in Montana, there is no misdemeanor warrant exception. You absolutely have the right to simply close your door. You have the right to be in your home free of government intrusion without absent a warrant or a warrant exception.
I got a text that my plane is departing a little earlier than I had planned, so I'm going to have to, and I don't want to get stuck in Detroit tonight, so I'm going to sign off. Thank you very much, counsel.
Thank you, Justice. Chief Justice, I think you're muted.
Sorry about that. You still have a few minutes. Further questions from the court? Seeing no questions, we will consider this matter to have been submitted. We'll take it under advisement. We'll issue an opinion in due course. Thank you very much to both counsel for appearing on Zoom. We hope someday to return to oral arguments in person, but this is the best we can do at this point. Thanks very much.
Thank you, Your Honor.
Thank you, Your Honors.
Yeah.